We were busy with the cell phone evidence and data, and that the state set out in detail that I deal with in the judgment based on the exhibits and evidence before the court that the accused is linked via his cell phone to relevant scenes. It was argued that the significance of the interpretation of the available evidence is that on the 22nd February 2018, the accused remained at home until approximately 7:32. This is a while after the deceased's cell phone shows no activity, namely from 7:09. This is just before the time when the BMW of the deceased is seen driving slowly past 28 Riesling Road at 7:34, being driven by a sturdily built white male. Then, shortly thereafter, at 7:45, the accused's cell phone ceased recording activity until 9:53 when he arrived at work. The state submitted that this evidence links the accused with the probable location of the death of the deceased. Between 14:11 and 14:26, the accused's cell activity was picked up by the cell tower located near Quintus Way and Kendall Road. The information coincides with the testimony and identification of Gray and the LPR video footage captured by Steyn. The state submitted that this evidence links the accused with the missing deceased and the BMW. At 14:37, the accused's cell activity was picked up by the cell tower located near the Deep River Railway Station. It is logical, as argued, that this information links the accused with a scene where the BMW was later found having been set alight, and as such, that this evidence links the accused with a missing deceased and a BMW. Between 21:18, shortly after he left his sister, and 22:16, when the accused was home again, his cell phone shows call forwarding. The state argued that, given the timeline of events, this evidence supports an inference that the accused not only was on the scene where the BMW was set alight, but he remained there or in the nearby vicinity for a while. This was also where he and his vehicle were observed by Thomas and Govender. It was submitted that all this evidence links the accused with a missing deceased and a BMW, and unless he can provide a reasonably possibly true alternative, it is indicative of his guilt. After the state had closed its case, the defense called Stephen Young, a detective warrant officer stationed at Deep River Police Station. He testified about the statement of Thomas relating to his identification of the accused at the Deep River Railway Station, where the deceased BMW was on fire. Thomas had said that he questioned and qualified the comment in his statement that the person he saw was coloured. Young, who did not take the statement but who commissioned it, after it had been taken down by another officer in another office, said that Thomas agreed with the statement and signed it when he commissioned the statement. This information is neither here nor there. Sonnenberg testified that when he interviewed Thomas twice after he had made the statement, he explained and qualified what he had seen. Rob Packham, the accused, testified. On 22 February 2018, he lived at 22 Riesling Road with his wife Gill, now the deceased. He was clearly a fit, exercise-conscious individual who testified about cycling and running. He had an extramarital affair which was disclosed to his wife in October 2017 after his daughter Nicola repeatedly, according to him, encouraged him to disclose this to his wife and to terminate the relationship. The disclosure resulted in marital problems, as a result of which marriage guidance counselling was sought, resulting in weekly joint sessions and individual sessions. He said significant progress was made during a difficult process. On the 21st February 2018, a joint counselling session took place at about 1700 hours. He said all sessions were full honesty sessions. He was often economical with information provided, with the truth of the information provided, but I gather that he made some hurtful disclosures which made his wife angry. After the session, they went for supper, travelling separately before returning home. Later that evening, they had an argument. Contrary to the testimony of Nicola, whose evidence had not been disputed, the argument had nothing to do with the counselling session, but related to him insisting on going to Johannesburg for a meeting the next day. Gill had, in inverted commas, significant trust issues, close inverted commas, with his absences, and she thought going away was inappropriate. He explained that his work and private matters should not interfere with each other. She became, in inverted commas, very angry, close inverted commas. The issue was not resolved, contrary to his statements in this regard. The next morning after his run, they both prepared for work. She repeated that she did not want him to go to Johannesburg, but he insisted. She threatened to phone the CEO of his company, a comment which he scoffed at. She went to their garage and left at about 7. According to him, there was building work taking place in the vicinity of their home at the time, involving different contractors. Sonnenberg, who was there the next day before 9, disbelieved and disputed this evidence. I regard this aspect as a contrived explanation for the disappearance and death of the deceased. It is highly improbable that builders will be ready to work in a residential area at 7 a.m. Nobody else testified to the existence of such builders early that morning, and in any event, if there had been workers around, they would probably have seen if something untoward was taking place. This evidence does nothing to enhance the credibility and the reliability of the testimony of the accused. He left his home at about 7:30 that morning and was later seen in a white shirt with his work logo at his work premises. He drove his white Audi Q5. His version is that he thought he would surprise his wife with a new vehicle for her birthday in March, although he conceded that she knew he was looking for a replacement vehicle for her. Accordingly, before he went to work, where he was supposed to clock in at 8:30, he decided to look at vehicles at car dealerships in the area of Bergvliet, Plumstead, Diefriver, Wynberg, and even Milnerton. He then went to his work at Belleville, where he only arrived at 9:47, 2 hours and about 17 minutes later, on a day that he was supposed to travel to a meeting in Johannesburg. The testimony is suspicious and improbable. It is unlikely that anybody who lives in the Wynberg area will go motor vehicle viewing or shopping during the usually gridlocked rush hour traffic over that time. There was no confirmation that he had been seen at any of the places he allegedly visited. It was never explained how the situation relating to his planned meeting in Johannesburg was dealt with, the alleged reason for a serious altercation with his wife. Having left in the throes of an argument, it is unlikely that he would decide to go vehicle viewing that morning. It does not tie up with his message to Miss X at 8:30, saying that he had overslept. The car search version was not immediately divulged in his statement to the police, nor to his colleague van Rensburg when he spoke to him. Why the vehicle search had to be conducted in absolute secrecy remains unexplained. Unless it was because he realized at some stage that cell phone data was going to relate his movements. The accused had 2 cell phones, a work phone and a personal private phone. He said he turned his work phone off when he left his home in his quest to look for a vehicle for his wife, but he left the private phone for communication with Miss X on. His wife did not know about the private phone that he hid away. His version was that his wife used to call him on his work phone and he turned the phone off as she was in the habit of tracking his movements and sometimes asked him to send a photograph to confirm his whereabouts. As he wanted to surprise her, he did not want her to be able to contact him. He turned his work phone back on at work. His version for the reason why he decided to switch on off his work phone for an extended period during this alleged activity is questionable and suspect. When he turned the work phone on at the Twiza premises, he received missed calls from his daughter's sister and the school where his wife was working. The school asked if he knew where Gill was, as she had not arrived at work. It was unreachable. He had not answered their call as his phone was turned off. Records show that he left the Twiza premises at 10:13 that morning, less than 30 minutes after arriving. He did not then tell anybody at work that he was leaving as his wife was missing, which is strange as his colleagues knew about his marital issues. He said he was perplexed and concerned, wondering if it was a motor vehicle issue, in which case one would have thought that he would have received messages from his wife, or he would have alerted the school, or she would have alerted the school. He drove to the school thinking that he would trace Gill from the place that she was supposed to arrive at. He even thought her car would be in the parking area and all the concerns unnecessary. Miss Moore from the school called him as he arrived, and he later spoke to her and another secretary. He was confused, as it was most unlike his wife not to be where she was supposed to be at a specific time, as she was very disciplined. He said it was not like her not to let him know if there was a problem. He was still convinced something must have happened on her way to school and that he would find her. He did not want to disrupt the school's running by involving management. From the school he went straight home. It was about 11 o'clock. He travelled backwards and forwards over the routes between the school and the home, including routes that she had told him she sometimes took. What is inexplicable in the circumstances is that he did not phone her repeatedly, but only twice, once at 9:58 and once at 10:18 that day, while calling his sister repeatedly throughout the day and his daughter several times. Mr. Gray testified to seeing him in his wife's BMW that had been stripped of its number plates at 1410 or thereabouts on the corner of Titus and Lucius Way in Constantia. Ms. Steyn testified that CCTV footage had picked up the same BMW in Kendall Road nearby at about 1417. The accused said he had discussions with his daughters during the morning about the possibility that his wife may have just taken the day off to go to one of her favourite places, although this was uncharacteristic. He said accordingly he went to the beach at St. James and returned home at about 2 or shortly thereafter. He says he was driving his white Audi Q5, and if Mr. Gray saw someone in a green BMW in Constantia, he had not been the driver, and the same applied to the CCTV footage seen of the BMW in Kendall Road shortly thereafter in the same area. He later agreed that the BMW that was spotted was indeed his wife's vehicle. His version is that after 1400 hours he left home again and drove to Hout Bay and Chapman's Peak to some favourite spots to see if he could find Gill or her car. He'd also been to a hospital in the area. It was argued by the state that it was strange that he never saw the BMW of his wife, as he was looking for it, as it was seen in the area where he was also ostensibly looking. It is also strange that he did not inquire from or involve the police at all, nor did he involve any friends or family in his searches. He only went to the Wynberg police station after suggestions by his family in this regard at about 17:30, where he was seen calmly busy on his phone, inter alia sending a message to his mistress. Even then, he did not report his wife as missing. He was asked to explain his call to and the message given to his colleague at Twiza van Rensburg, a message referred to as an attempt at an alibi. Van Rensburg testified that the accused had phoned him at 12:23 to ask him to say that he had been at work from 8:30, where they had a meeting. The explanation of the accused for this call and the follow-up message to Van Rensburg in the same vein is one of the vexed issues of the matter. In explanation, the accused testified that he had exhausted all logical options of where his wife might be when he phoned Van Rensburg. Although on his own version, at the time, he had not explored all logical options. He thought Gill may have gone to his work to look for him in a quest to track his whereabouts, and he thought he would let somebody at the plant know that she may come to the plant, and that if she did, to give her a message, which was not true. The message that the person had to give was not true, but was false. He had not inquired at the plant if his wife may have had been there, not when he was there earlier or telephonically subsequently. It was never shown why Van Rensburg was singled out to relay this false message. The version of the accused, while testifying, differed from the propositions put by his representative that the message was directed at his wife if she called. There was no reference to her possibly arriving. It was disputed throughout by Van Rensburg that the accused said to him that if Gill was to call, he should let her know that he had been there since the first thing that morning. The accused said he told Van Rensburg that Gill had been reported missing and that he was concerned about her whereabouts. The version of Van Rensburg is that the accused asked him, in inverted commas, if anybody phoned, close inverted commas, to say that he had been there since 8:30. It was later pointed out to the accused by the state that his version relating to a message to Gill if she phoned or came to the plant was new and had not been put previously. He did not respond to the questions in this regard persuasively. He conceded that the information he wanted to be relayed was not true, but explained that he was still in car hunt mode, in inverted commas, and he did not want Gill to find out that he had been looking for a car for her as the reason why he was not at the plant, a version not relayed to Van Rensburg. As argued, I agree that the explanation was improbable and unlikely. By this time, the accused had been searching for his wife for about 2 hours, saying he was at his wit's end, indicating to all who he was in contact with that he was distressed. It did not appear that his main problem was that his wife would find out he wanted to buy a car for her. If he had these concerns about his wife finding out about his car searching, why did he not tell everyone at the office to cover for him if she arrived or called? Why did he give a time from when his movements needed to be covered? Why ask van Rensburg, who had never had calls from the deceased? The only logical conclusion is that he wanted anyone who inquired to be given a false alibi for his whereabouts from 8:30, when he was supposed to be at work and was not. He said he did not want Gill to know he had not been at the plant, which is nonsense, as he had been at the plant. He specifically wanted her to think he had been there since 8:30 for an unknown reason. The entire version of the accused on this aspect, adjusted in his testimony, is questionable and highly improbable, especially when his follow-up message to van Rensburg to perpetuate the lie is considered. Van Rensburg's testimony on the subject, on the contrary, also compared to a statement he made to the police, remained consistent and reliable, credible and probable. Throughout this day, on the accused version, he must have been very stressful. He searched for his wife on his own, without seeking any assistance, which is unlikely and incomprehensible. When he went to the Wynberg police station only at 7:30 that afternoon, he allegedly finally wanted to report his wife as missing, which was not done. His daughter in Johannesburg had done more to search for her mother than he did, based in the area where she went missing. According to him, someone at the police station advised that the person could only be reported after 24 hours, which was questioned by the police, who say this was not the case. When he wanted to report his wife missing, it was explained to him that he should be at the Deep River police station, but they would send the information through in the meantime. He filled in forms, admitted to marital problems, but did not think that their argument was of any concern to the police. He did not tell them that he had been vehicle searching and that his phone had been switched off either. Instead of going to the nearby Deep River police station as suggested, which would make sense, he went home, from where he went to his sister in Turkey for supper. He had repeated contact with his daughter and especially his sister during the day. They said he had been weeping, so distressed was he. This makes it more improbable that he would ask van Rensburg to lie to Gill about his whereabouts, confirming this message days later when he knew or at least suspected that Gill was deceased. By then, his secretive alleged car searches were irrelevant to Gill. He also said he was concerned that she was not contactable on her cell phone, while evidence showed that he only tried to phone her twice, in quick succession during the long, distressing day. The accused arrived at his sister's house in Turkey at 19:08 as testified by Harvey, based on cell data provided. He was driving his white Audi Q5. The record shows, and he agreed that he left at about 21:17. While at his sister's home, he had telephone discussions with his daughters on a landline or cell phone. After leaving, he went home, according to him, but he corrected himself to say that he first went to Constantia Clinic emergency section. When he arrived at home, his cell battery had died and he put it on charge, just as Nicola phoned and then his sister. He thinks the phone was probably off for 10 minutes. But according to cell phone data, his cell phone was off from the time he left his sister at 21:17 until 22:16, nearly an hour, not 10 minutes. What person who is desperately searching for his missing wife will risk being uncontactable on their phone for an hour while having a charger in their vehicle, as he conceded? His sister called at 22:17, an hour after his departure, according to cell data, to say she was coming to fetch him, after she had been alerted to the BMW being found. This time frame, 22:17, corroborates the probability that the car was not found burning just after 21 hours, as the accused tried to make the court believe. The accused explained about Nicola's involvement, Facebook, and the information about the burning BMW at Deep River railway station, as testified earlier. He testified that after being fetched, he went with his sister and Gill's friend to the police station at Deep River, from where they went to the railway station to see what was happening. He agrees it was a hive of activity with cars and lights. As they got out of their vehicle, a police officer said they were not allowed closer and they went straight back to the police station without having a conversation with anyone. I accept that this is what happened, as it was corroborated, but this is one of the situations that troubles me. The accused is not a tentative man. He's been shown to be controlling and forceful and not at all inclined to follow instructions. And I find it very improbable that if his version is true, and if he was really as distraught as he said he was, and as he should be in the circumstances, that he would without a word turn around and leave the area meekly. I would be more inclined to think he left quickly, as he was concerned about coming into contact with the person who saw him earlier on the scene, Thomas. A counsellor, Nicky, was waiting for him at the police station, but from his testimony it appears that he did not require counselling, which is strange. He maintains he found it frustrating and awkward, as she had no information, although she did say a body had been found in the vehicle. He said that was, in inverted commas, difficult news, awkward and inconclusive, close inverted commas, brackets, but not so difficult that he rushed back to the scene, close brackets. He said he did not need counselling, although after this news, nothing could really have been inconclusive, and a genuinely grieving, distraught husband would require counselling. He said that he was numb and in shock and signed a missing persons document before leaving the police station. He also said he only got home after midnight, although previously he complained that Sonnenberg had called him after midnight. He insisted he was not the person Thomas saw. He was at his sister's house at the time. Sonnenberg phoned him either when he was at home or when he was en route. He wanted to take his statement, but he did not want to go as he was tired. I've noted that it is strange that he did not want to go to him straight away to get the information he was allegedly so eager to get earlier. He says he suggested a meeting with Sonnenberg at 8:30 the next morning, while Sonnenberg said the meeting was scheduled for 8. But the next day, the accused was not at home or at the station, not at 8 and not at 8:30. The police eventually went to his house and waited. He said that he arrived at his home at 8:20 and was then going to head down to the station, but it later transpired that he actually only arrived after 9, after he had been for a long drive along the coast to Sea Point, again in rush hour traffic, not indicative of a man who is anxious for news about a missing wife in whose burning BMW a body had just been found. He later said he forgot about the scheduled meeting, which indicates his lack of interest in details of the investigation. He complained about the way the police treated him and about them taking photographs of his car on the 23rd February. Brackets, further photographs were taken in August 2018, subsequent to which it appeared from the testimony of an expert that the tyres may have been changed before the second set of photos were taken, close brackets. Why he was unhappy with pictures being taken of his Audi escapes me. His cell phone was taken from him on 23 February. He was asked for a PIN number that he said he gave. However, the PIN was wrong, and to today's date his cell data could not be accessed. Later he said that when he was asked for the PIN again, he had forgotten it. And in another statement he said that he did not feel like giving them the PIN number after they lost it. Conflicting versions. At the police station he gave a statement, Exhibit J, which stated that he had left home soon after his wife left at 7 a.m. and went to work on the 22nd February. Nothing was revealed about a surprise gift vehicle search or deactivation of his phone. He was arrested on 1 March while he was entertaining friends. In due course, a disciplinary hearing was held at his work that he did not attend on the advice of his lawyers. He supplied human resources at his work with what they regarded as an unsolicited, inappropriate affidavit K to provide his version of events. After he was dismissed at his work and before he supplied this affidavit, the matter was referred to CCMA. I dealt with K when dealing with the testimony of Terry Adams. About the blood samples found at his home, he said that the blood of the deceased in the garage was, as far as he was aware, because on Sunday, 18 February, brackets, when he had allegedly returned from Johannesburg according to witness X, and which testimony was not disputed or explained, brackets, his wife had taken away recycling and in the process cut her hand at the bottom while putting bags in his car. We assumed it was broken glass, he said. He suggested that some of the blood found was from this cut. She allegedly mentioned it to him, and she had put plasters on the wound. He then, by way of unrequired support, states that his sister testified that Gill had a plaster on her hand when she saw the deceased earlier in the week. In brackets, she actually said a bandage, which is more extensive. Close brackets. The post-mortem report recorded the presence of a plastic hand brace on the arm of the deceased, a different arm to the one the accused said was injured. The accused speculated that the blood of the deceased found on a bag of fertilizer may have been when Gill pricked herself on a thorn. As regards his blood found in the bathroom of the house, he explained that, as often happened, he had probably cut himself shaving. He denied any involvement in any attempt to dispose of the body of his wife by setting fire to a vehicle. The cross-examination of the accused by Advocate Galloway was detailed and continued for days, during which time the accused became more and more confrontational and frustrated. She put to him the testimony by the medical practitioner, suggesting inter alia that his wife had died of forceful blows to the head. The accused agreed that one could assume under such circumstances that such a person intended to kill her, a very small person of 5 foot, weighing less than 50 kilograms. Her small stature is also noticeable on the photographs of the family in exhibits before court R and M. The accused has a much bigger, sturdier build. It also ties in with the testimony of the witness, Steyn. The accused maintained that, considering all the events and the type of person his wife was, her death on the day must have been the result of a random hijacking with a BMW or an attack outside his home. There is no other explanation on his version how she ended up locked in the boot of a BMW that was then set alight. His responses to these questions were inappropriately casual in the circumstances and in the context of the topic. In inverted commas, I guess so, close inverted commas, and asked if there was any other explanation, inverted commas, afraid not, close inverted commas. For a bereaved husband, he exhibited an unexpected lack of concern on the subject. There was no break-in or house robbery or any other attempt at their home during the evening of 21-22 February. After he was advised that his wife had not arrived at her work, the accused went home on several occasions during the day. He found the house fine, alarm on and security gate locked. Nothing was missing from the home. He also said casually, matter-of-factly, that Gill may have been attacked in the garage. He did not follow her to the garage when she left. However, he had not recorded that he saw anything untoward in the garage when he left shortly after her. Until 30 March, he was under house arrest and spent his time at home. However, we were advised that he had personally delivered flowers at the workplace of Ms. X. The disciplinary hearing at his work was discussed. His bail conditions could have been amended for this purpose. When he sent the statement K to Ms. Adams, he had already been dismissed by Twiza, but the CCMA hearing was pending, where he said he wanted to present his version. He said he was frustrated at not having his say at the Twiza disciplinary hearing, despite advice from his representatives to avoid contact. Instead, he risked his bail conditions being cancelled by sending his version to the HR manager of Twiza, an example of his repeated disregard of most instructions. The accused was referred to Exhibit O, page 3, the email dated 18 May to Ms. Adams, advising her that he was sending a confidential email later and wanted to meet her. He refers to the misunderstanding, in inverted commas, between him and van Rensburg, which had, in inverted commas, catastrophic, close inverted commas, implications for him. He also sent her an affidavit commissioned on 18 May dealing with his request to van Rensburg, setting out his version of his marital problems. Based on the information already supplied in this matter, his version was carefully structured to put him in a better position, and he was clearly economical with the truth in numerous respects. He noted, for example, that he ended his affair in October 2017, while this was an outright lie. He objected to the allegation, in inverted commas, that he attempted to coerce van Rensburg into making false statements about his whereabouts on 22 February, while the statement he required was clearly false. His statements about the great progress in rebuilding his relationship with his wife ignored his ongoing intimate relationship with Ms. X and discussions with her about divorce. Brackets, we heard that his wife was also considering a divorce and had obtained an example of a settlement agreement. Close brackets. He recorded that his wife checked his phone for messages, but he did his best not to add to her concerns. He did not reveal details of the argument with his wife the evening before she was murdered, but mentioned the car search version for the first time, without mentioning that he had switched off his phone. He repeated his version of his request to van Rensburg. He notes in the affidavit that when he got a call from the school, he repeatedly tried to phone his wife, which is not true. He did not want her to know about the car search, and that is why he rang Ludovit at the plant as he left, it was not quite right, and asked him to cover for him if by chance she was to call to check where he was. He did not say here that it was if she arrived. This was not consistent with his later version. He asked Van Rensburg to say he was at the plant from 8:30 and maintained that it was a harmless personal request. This is now all in the affidavit marked K. Then in this affidavit, he inappropriately mentions the naughty pictures incident between him and Van Rensburg, where his version differs from that of Van Rensburg in a transparent attempt to discredit him, insisting that he did not want Lodewijk to produce an alibi for the authorities. His request was that Lodewijk should give only his wife a false message should she call or visit the plant. He even speculated that Lodewijk was under pressure by the authorities, but the truth is that he relayed the information voluntarily, as he and other colleagues were understandably uncomfortable. He was not allowed to contact Lodewijk any longer. He thinks because he persuaded the police that he had tried to coerce him into making a false statement on his behalf, semicolon, which is what happened. The accused avoided mentioning that he repeated the same request to Van Rensburg by phone message after he became a person of interest and his wife BMW had been found with a body inside. This was a second attempt to get Van Rensburg to support his false alibi. The accused admitted that the only time he asked colleagues to cover for him with his wife was that day to Van Rensburg, an admission that makes his version even less plausible. To explain the email he sent to Adams, he insisted, unpersuasively, that he was looking for advice from her as a colleague after the disciplinary hearing at Twiza had been finalized. This allegation is improbable, as he had two sets of lawyers and a therapist advising him at the time. The contents of the affidavit of the accused contained in Exhibit O were inaccurate and or false in numerous respects, and is a transparent attempt at manipulation, merely to put him in a better light. The accused agreed that his face, as seen in photographs before court, used to be much fuller. The same applies to his stature. He did not wear glasses in the pictures posted, but wore these for reading and long-distance viewing, and has several pairs. Thomas said he saw him without glasses at night. On 22 February, he was driving his car, a white Audi Q5 with number CA245-719. On the same day, his wife's dark green BMW went missing. He agrees the vehicle seen in the CCTV footage of number 28 Riesling Road on 22 February, as depicted in Exhibit W, and the video clip of such footage contained in Exhibit FF, was the green BMW that was noticed by Gray at about 14:11 and was then picked up shortly thereafter by the technology of Ms. Steyn at 14:17. He agreed that it was his wife's BMW, the same vehicle that was found burning at the Diep River railway station nearby later that night. The aspect of his argument with his wife and his version of the reasons for such argument was traversed again. He insisted that the argument was about him going to Johannesburg, despite the evidence to the contrary by Nicola, which he had not disputed. On the morning of the 22nd, he was still planning to travel to Johannesburg. As noted, it was never clear how he went from planning to go to Johannesburg to go looking for a vehicle for his wife. He argued with his wife, defied her request and wishes, and then went searching for a new vehicle for her, a questionable version that could not be explained satisfactorily. He denied the proposition that on 22 February he was in a relationship with his wife and Miss X, and that he gave conflicting messages to the two women about his commitments to them. He explained that he and his wife were receiving counseling with the encouragement of Miss X. This evidence was contrived, considering that he and she went away together and were in frequent contact until she broke off the relationship a month after his wife's death. His insistence that he was 100% committed to a reconciliation process was shown to be a lie. He was seeing lawyers about a divorce while attending counseling sessions and allegedly planning the renewal of their vows. The allegations by the accused that there was full disclosure and honesty during the counseling sessions were a lie. He did not reveal the extent of his continued contact, including a private phone and trips away with Miss X to his wife. Nicholas said that disclosure had been the issue regarding the session on 21 February, which he did not dispute when she testified, but which he countered with a snide comment to Advocate Galloway that she was not at the session that afternoon. He was reminded that Miss X had said that on 21 February they sat in his car, and that he said again that he needed to make a decision, but he wants the court to believe that in all the circumstances, After commenting that the situation could not go on indefinitely, he was actively looking for a new vehicle for his wife, just after a serious disagreement and while en route to Johannesburg. He says he told Gill about some of the discussions he had with witness X, and, not surprisingly, she was not happy about it. He thought his communications were constructive and that Gill would see Miss X not as an enemy, but as someone who was part of the solution. The incredulous response of Advocate Galloway to this testimony is shared by the court. The extensive testimony of the accused in this regard defied all credulity, as did his further comments about disclosure and the status of his relationship with Miss X at the time, not to mention his sarcastic comments in response. He had to agree that his comment in the affidavit K, that he had ended the relationship with his mistress, was untrue. The accused admitted that he continued to make contact with Miss X when she made it clear that she wanted to break off the relationship. He said he received conflicting information from common friends, despite being told by his lawyers to stop contacting her. Brackets, another example of him ignoring requests, close brackets. He was reminded of the message he sent to Miss X on 24 February, 2 days after his wife went missing and her car was found alight. The message, sent at 2 a.m. one morning, was that the madness would soon be over and then they could be together. He said he did not recall sending such a message, but did not deny that he did. The message indicated that they were still in an unduly intimate relationship that he wanted to continue, which he denied, but he agreed that it may have given that impression. The accused eventually conceded that it may appear that he was sending conflicting messages to different people. He was thinking of divorce, had said he did not love his wife, but was telling others that he was committed to saving his marriage. Their common friends, in inverted commas, knew he was still involved with Miss X and therefore passed on his messages, but his own family did not know this. The accused was admittedly living a double life, defined by deceit on different levels. The blood that allegedly resulted from a cut to the bottom of the right hand of the deceased when attending to recycling caused confusion with regard to the post-mortem report and the testimony by Dr. Molefe, who noticed plastic-like material around the left hand of the deceased associated with silver tools, possibly an arm brace. He denied that there was such a brace on her arm. A plastic brace would not be likely in the event of a cut, such as testified to by the accused. The accused admitted in cross-examination that he only attempted to phone his wife twice on the fateful day, a fact that leads to a conclusion that he was not that interested in finding her, clearly, not only probably, as he knew he would not be able to reach her. He agreed that when he left home at about 7:30 that day, he saw nothing indicating that anything unusual had happened. He could not explain how it could happen that his wife's car drove slowly past number 28 Riesling Road about the same time that he left. Her BMW was not trying to get away, as one would expect from a hijacking or theft, while the vehicle was apparently driven by a white male wearing a baseball cap. Advocate Webster objected, but Advocate Galloway and Sonnenberg were quite correct about what is noticeable in the video footage of FF, as I have recorded. The accused tried to excuse himself by saying he went the other way, towards Main Road, but it is logical that her car must have been at or outside his house 4 minutes before being seen outside number 28. According to Exhibit CC, page 5, he was still at home at 7:28. He said he left home at about 7:30. Yet the first time he is seen on that day was when he arrived at work between 9:47 and 9:53. His testimony on the subject of the message to Van Rensburg remained suspect throughout the proceedings. Inter alia, he could not explain why he wanted Van Rensburg to move away with his phone from other people in the vicinity. The obvious thing to do, on his version, was to say to everyone to ask his wife to contact him if she called, as he was looking for her. The reason for the time specification of 8:30 remains, as I've said, unknown. He did not want Twizza to talk about his marital problems, he said, but previously had said it was an open secret. If he thought his wife was missing, one would think it was serious enough to warrant everyone's assistance, and it was a good excuse to be away from work. On the same subject, when the accused was questioned again about what exactly he asked Van Rensburg to say and do, the accused was vague. He repeated that he asked him clearly, although he misunderstood, that he must keep an eye out for Gill, and that if she came to the plant, he should let her know that he had been there from 8:30 and that he had gone to look for her, and if she called, he must give her the same message. This version differed from his earlier testimony and from what was put to van Rensburg and from the contents of the email on the subject. When it was pointed out that this was new information, he continued adjusting and amending his version. Van Rensburg had said, in inverted commas, "I have no idea why he phoned. He asked me to say if anybody phoned, he must say that at 8:30 we were at the production plant in the meeting," close inverted commas, brackets, which is also what he told Nicola when she phoned. One inference, if not the only inference, is that the time he required to be given was the time when he was in a compromising position somewhere requiring an alibi. The accused insisted that he said that if Gill called or came to the plant, she had to be given a message, but this was not put to van Rensburg. Previously, his version on the message aspect was that needed to be given if she called. Advocate Galloway reminded the accused that the issue was whether he called, whether he added the aspect of the arrival at work, which was new. His response was nonsensical and not credible, as was all his evidence on this aspect, especially considered the unexplained cell phone message to van Rensburg that followed on Sunday the 25th February. As noted, he had initially asked van Rensburg to lie on 22 February, and in his later message on 25 February, he wanted the lie perpetuated by reminding him about the hookup at the plant on Thursday at 8:30. His responses on this subject remained unpersuasive. He did not qualify his message to van Rensburg or set the record straight, according to his alleged version. The message requested twice was a lie and a very clear attempt at an alibi for a specified time. On his current version, van Rensburg was supposed to cover his movements for the sake of his wife, whom he wanted to surprise with a new vehicle. His wife had passed away. The same lie was told to his daughter when she contacted him on the 22nd. He told her he had been on the floor at the plant and there was no indication why he decided to lie to her. Viewed in its totality, the version of the accused on this subject was totally improbable and, as argued by Advocate Galloway, was incriminating and indicated his guilt. The accused was asked about another lie, a message that he sent to Miss X at 8:30 on the morning of the incident, namely that he had overslept, which was not his testimony. His response was that he had forgotten to send her the usual good morning message, avoiding giving a reason for the lie. It must be noted that although Advocate Webster complained that Advocate Galloway was interrupting the accused, the record actually shows that the accused was the person who interrupted Advocate Galloway frequently, while getting anxious and agitated, ostensibly as a result of his inability to explain his conduct. As regards his two cell phones, he said that the private phone was hidden at his home when he was not using it, testimony contradictory to full and honest disclosure to his wife. It emphasizes deceitful conduct, not just hiding a phone, but pretending to be open and honest. He was asked what phone he used to text Miss X on the morning of 22 February, as his known phone records did not pick this up, but he would not say, and amended and contradicted his previous version to say he did not recall sending such a message, as he denied remembering the late-night email to Miss X that they would soon be together. He added sarcastically, in inverted commas, "ask your expert," close inverted commas. When asked why he had changed the tires of the Audi, and after the relevant implicating pictures were shown to him, he said that he did not know if the pictures shown and admitted in terms of the Section 220 statement were of his vehicle. He became very agitated and denied changing the tires of his Audi, maintaining that the pictures shown were not of his Audi. Advocate Galloway argued that the tires of the Audi were changed after the accused became aware that there was a witness who saw someone running and driving from the burning car. As the cell phone calls and links to cell towers have been dealt with in some detail, I will not repeat his testimony under cross-examination relating to this aspect. Safe to point out that the accused left his work on 22 February after arriving shortly before 10 at about 10:18 and started driving around by 11 after having been to the school. He then went back home and later on started to drive to Kalk Bay and surrounds. His phone was picked up in Constantia Dale B at 11:30 and he said he had travelled between the school and home, which was supported by his cell data. He agreed that he arrived home again between driving trips at about 1400 hours. The accused conceded that he was at home at 11:19 when his phone was picked up by the LTE Constantia Dale CT West Tower, That was when he saw that the house was locked and the alarm was on. The accused insisted that when Steyn's technology picked up his wife's car, he was at home, 2:17. But he said at one stage he nipped into the Little Orchard nursery, which is down Kendall Road, and that may have been when the Deep River cell tower picked him up, near the railway station, where the burning BMW was later found. He said he drove in and out of the nursery at 14:37 on the 22nd February and then went back home. This was new testimony that I believe was fabricated to fit in with cell data and testimony that he realized was compromising. Exhibit CC shows that the accused arrived at his sister's home at 19:08, linking to the Polesmore Tower, and he left at 21:17, brackets page 12, close brackets. Advocate Galloway showed that it took him 11 minutes to drive from his home to his sister. After he left his sister's house at about 21:17, his phone was off from about 21:18 for a considerable period. He said the battery was dead, although he admitted he could have charged it in his vehicle and that he had a habit of plugging it in, but he says he's forgot. I believe if news of his missing wife was important to him, he would have made sure that his phone was properly charged at all times. Exhibit C, page 12, indicated that his sister called him to fetch him at 22:17. This was when it was known that the BMW had been spotted at Deep River Railway Station. Even if it was then known that the vehicle was on fire, which was not the testimony, it shows that the BMW had not yet been discovered ablaze before 21:30, as suggested on behalf of the accused. What exactly transpired at the Wynberg police station that afternoon was a subject of debate. What is of interest to me is that he was told that he should report his wife missing at the Deep River police station, but he did not go there. He went home and then to his sister. It indicates a lack of interest in reporting the matter. His weak explanation in this regard was that he forgot, which had been an excuse on other occasions also when he could not explain his conduct. I have dealt with other aspects indicating his lack of interest in establishing what had happened to his wife, such as not insisting to get information from the police at the scene of the burning BMW, not being prepared to speak to Sonnenberg when he called, and not being available at the agreed time when the police wanted to talk to him the next day. He also never visited or called Sonnenberg to be updated on the progress of the investigation, saying unconvincingly that he did not want to hound him, preferring to rely on his children for information. During the last part of the cross-examination, the accused became flustered, did not concentrate, kept on trying to look at the documents before him or at members of the public, which indicated the possibility of an attempt to adjust his evidence to conform to the exhibits. His retorts to Advocate Galloway became cheeky, and his previously mostly composed demeanour disintegrated. The aspect pertaining to the evidence of Mr. Gray, who identified the accused as the person he saw in the BMW of the deceased at number 5 Lucius Way at 14:11 on 22 February, was traversed again, with reference to exhibits such as Exhibit H with photographs of the area, example picture 46, A 1990-28. As demonstrated on Google Maps, the home of the accused at number 22 Rieslinger Road and number 28 Rieslinger Road, where there was a CCTV camera that picked up the BMW of the deceased at 7:34 on the 22nd February, are in close proximity to 5 Lucius Way. These places were also close to Kendall Road, where CCTV cameras picked up the vehicle of the deceased 3 minutes after Mr. Gray saw the vehicle in Lucius Way and the Deep River Railway Station, where the vehicle was later found and where Thomas testified to seeing the accused in his white Audi. The points where Thomas says he observed the accused sitting in a car that matches the description of the Audi of the accused were indicated. The pictures presented to court show how the BMW could have driven from Lucius Way and Mr. Gray past the Kendall Road cameras of Miss Steyn and then into the Deep River area where the station is, and where the white Audi, allegedly of the accused, was seen. The person in the Audi, similar in colour and model to that of the accused, with a similar number plate with a person likened to him, were found in the same area as where his wife's blue BMW burned down with her in the boot. This location is not far from the home of the accused, who admitted that he was in the area of his home at the time. Despite the defence's objections to the identification, it is admitted and a fact that the person seen in both the BMW and the Audi looked enough like the accused for him to be identified as the driver, despite him having lost weight and wearing glasses at times. It was never argued or considered a possibility that the person observed, as noted, was a woman driver. Ms. Steyn testified that it was noticeable to her, a person well acquainted with observation of vehicles and drivers, that the person driving the BMW before the license plates were removed was not the same person, and that the stature of the driver differed. The accused agreed that it was not his wife driving the BMW after 1400 hours on 22 February. Advocate Galloway put to the accused that on his narrative, the deceased must have been attacked early on Thursday morning, and hours later the perpetrator was still driving in the vicinity in the vehicle of the deceased. His response was that, in inverted commas, it appears so, close inverted commas. The improbability of this scenario is undisputable and was irrefutable. The accused was referred to Exhibit CC, page 8 with regard to the time slot 1400 hours on 22 February, indicating the end of one of his road trips, according to him in the search to his wife. His phone activity was at LTE Plumstead, Cape Town West at the time. Then at 14:11:49, his cell phone activity was picked up by the BL agency's CT West Tower. Advocate Galloway had indicated that Quintus Way / Lucius Way was connected to this area, where his phone remained until 14:12 or later, before skipping at 14:26 to Lower Constantia CT West. His evidence had been that he left home that morning at 7:30, linking him to Constantiadale, Lower Constantia, and then at 7:37 to BL Agencies West, indicating that from his home, his phone moved to BL Agencies Tower, from where it moved to Deep River, where he said he agreed as he went to a car dealer opposite the police station in Deep River. But it was shown that when his wife's car was seen driving past 28 Riesling Road, his phone was in the same area. He said it was not him driving his wife's car from home in the direction of BL Agencies. He became confused with the evidence and did not appear to see that BL Agencies and Deep River were two different towers. The accused agreed that on the morning of 22 February, from around 11 and until 1400 hours, he was driving close to his home, between his home and the school, and it was shown that he and the person in his wife's BMW must have been driving in the same area for about 3 hours, and despite various sightings of his wife's vehicle and him searching for it, he never saw it. The next sighting of his wife's vehicle after it had been seen by Ms. Steyn was at 21:30 at the Deep River railway station, where it was then set alight. There was some argument about the time the BMW was set alight. He said it was seen earlier and was referred to the testimony relating to relevant times by Governor, who said with conviction that the time of the commotion was at 21:30. He was sure as he looked at the time on a clock on the wall. Other evidence on the subject amounted to estimates. Advocate Galloway put it to the accused that it would not be impossible for him to drive from his sister's home to Deep River Station in 10 minutes that evening, and coincidentally over this crucial time, the battery of his phone had died. The accused testified that his phone was off from 21:48, which is wrong. Exhibit CC, page 12, indicates that his phone was off immediately after having left his sister at 21:18 until 22:16 that evening, an hour, an aspect not explained by the accused. Further argument again ensued relating to the person and his characteristics identified by Thomas, but Advocate Galloway reminded the accused that the witness did not only identify him, he also identified his white Audi. The response of the accused was that it was a fantasy and coincidence. Even the fact that the registration numbers matched in material respects, and despite the possibility of a match in tyre imprints, according to evidence. The accused maintained throughout that he could not have reached the railway station from his sister's home when it was said he was there. In brackets, in inverted commas, the rest of it, I'm afraid, is fiction, close inverted commas. I do not intend to deal again in detail with the blood mark testimony that the accused was questioned about, with reference to Exhibit F and the places where visible spots and bigger stains of blood have been found. Bigger blood stains of the deceased blood found on the metal frame of the inside of the garage door at the home of the accused were pointed out to him, as well as blood on the door into the house. The version of the accused that the deceased had cut herself on the recycling material or gardening material was repeated. He did not know where the respective blood spots, drops or stains were from, but then ventured for the first time to suggest that it could have been from an attack on the morning of the incident, excluding the blood on the inside door handle of his vehicle. In closing, Advocate Galloway put the following possible scenario to the accused: that the deceased was attacked or hijacked by someone at about 7 on 22 February 2018, subsequent to which the perpetrator stayed in the area where the crime was committed many hours with the body of the deceased in the boot of the vehicle, not worried about being stopped as the vehicle missed its number plates. Then, after some driving around, the vehicle, presumably the prize for which the crime was committed, was locked and abandoned and later set alight. The accused said that was a possibility, but he did not know. Advocate Galloway pointed out, correctly, that was the inference the accused wanted the court to draw from his extensive testimony, to which he repeated that he just did not know and did not want to speculate. Advocate Galloway then argued that, on the morning of 22 February, the accused hit his wife with an unknown heavy object, first on her jaw, incapacitating her, then a second blow was inflicted over the side of her head towards the back, which killed her. This occurred after the parties had an argument, and the accused found himself in a tight spot due to his long-running affair with Miss X and his wife's inability to deal with his infidelity and disclosures in this regard, threatening to confront the CEO at his company. It was suggested the attack may have occurred while the deceased was already in her car or getting into her car on her way to school, and the blood droplets in the garage were from the accused or the weapon. He then transferred her or placed her in the boot of a vehicle, which explained her blood found on the inside of the garage door, also explaining the second post-mortem injury to the head of the deceased. Having handled the murder weapon, that explains the blood found on the inside of the right-hand door handle of the vehicle of the accused. That explains why the accused did not report his wife as missing and why he did not enlist in the search of his wife, why he did not enlist help in the search of his wife, and why he appeared calm to the police officers at the police station. After being spotted by Mr. Gray, the vehicle of the deceased was left, locked at the Deep River railway station. Ms. Galloway submitted that the driving around in his vehicle was an attempt to find places to rid himself of incriminating objects such as number plates, other objects, and the murder weapon. After dinner at his sister's home, he switched off his phone and drove to the place where he had left the vehicle of his wife and set it alight to dispose of remaining evidence. Not surprisingly, he did not wish to go closer to the scene of the burning vehicle, nor was he interested to go and see Sonnenberg the next evening, and why he took a joyride when he had a meeting with Sonnenberg the next day. The accused denied categorically the proposition the state had described and suggested, but apart from a hijacking hypothesis that was shown to be unlikely and totally improbable, he had no other suggestions. I then deal with the evaluation of state witness testimony. I'm satisfied with and accept the evidence of all the state witnesses whom I find honest, reliable, consistent and credible, and whose versions, when carefully weighed up, were reasonably possibly true. After applying caution, common sense and logic, I accept the testimony of the witnesses Gray and Thomas. I find that their evidence was bona fide and reliable. The evidence was corroborated by other witnesses, other testimony or cell phone evidence. The response of the accused to their evidence was unpersuasive, unreasonable and improbable and is rejected. Gray and Thomas both had a good opportunity of observation. The testing of the reliability of the observations supported the evidence. They were not hampered in their observations by lighting, visibility, obstructions, eyesight, or proximity to the object of the observation. They were not familiar with the accused and harbored no bias against him, nor did either of them have any motive to implicate him falsely. They both observed the expressions on the face of the accused and noticed his sturdy build. Any uncertainty by the witness Thomas about the race of the accused was explained and qualified and could be attributed to the circumstances. Further identification of the accused by these witnesses at the photo identity parade and in court confirmed their testimony. There may have been shortcomings or imperfections in the photo identity parade, but I do not believe, considering the totality of the evidence presented, that these imperfections carry so much weight in the circumstances where the imperfections were explained. I'm satisfied that the identity parade was set up in a fair, independent, objective manner. The testimony of the state witness Ludwig Jansen van Rensburg was attacked relentlessly by the defense. He was consistent in his testimony that in turn was consistent with his affidavit to the police. His version was credible, reliable, honest and probable, as opposed to the improbability of the varying versions of the accused on the subject of the alibi requested van Rensburg to confirm. The testimony of the investigating officer Sonnenberg was similarly honest, reliable, credible and entirely probable. His conclusions and suspicions relating to the accused were well justified, including his perception that the accused exhibited a lack of interest in reporting or finding his missing wife and in the progress of the investigation to establish the cause of a violent, unusual death. I think at this stage the accused can just stand up because I'm now dealing with an evaluation of his testimony. The state set out the material aspects pertaining to the matter, indicating the dishonesty, unreliability and improbability of the testimony of and versions of the accused, compared to the version presented by the state that I have set out and discussed in detail. This includes many instances where the accused was shown to have lied or to have changed his version, included the inexplicability of him switching off his phone at relevant times. There was also his request to van Rensburg twice to provide him with an alibi by relaying a false message that he could not explain satisfactorily. The same false version he relayed to his own daughter about where he was on the fateful morning at the relevant time. The conclusions about the disinterest of the accused with actually finding his missing wife and the investigation into her death have been dealt with, as have the testimonies of the witnesses who observed the accused in compromising circumstances, in either his own vehicle or that of his wife after her disappearance. As noted, the versions of these witnesses were corroborated in material respects. The accused did not act in a manner expected of a distraught and later bereaved husband, and when he was challenged about his conduct, he responded in a manner incompatible with the situation. During the proceedings in court, the accused did not express emotion, not even when the pathologist gave gruesome evidence of the injuries to the deceased. He mainly showed frustration and impatience with evidence presented and questions asked. His sometimes snide comments in response to questions from the state did nothing to encourage sympathy. The accused has shown to be an accomplished liar and deceiver who deceived his wife and to an extent his paramour as well as his family. He misled his family and wife about having terminated his extramarital relationship and about his commitment to honesty and repairing his marriage, while continuing an intimate relationship with his mistress. The mistress he pursued relentlessly, even after his wife's death and after she received lawyer intervention to request him to stop. While proclaiming that great progress was made in reconciling with his wife and the success of the marriage counseling, the accused went away with his mistress without his wife's knowledge, only weeks before her death. At about the same time that he had been consulting divorce lawyers, he was buying an eternity ring and planning a renewal of marriage vows. I mention these aspects as it is relevant to his credibility, aspects that show that the accused was a crafty, competent deceiver who was living what has been shown to have been a selfish, destructive double life, even to the extent that he had common friends with his mistress who apparently supported their extramarital affair. The conduct of the accused was not consistent with the conduct of a reasonable person in his position. In the totality of the evidence before me and the circumstances of the case, I agree with the state that his conduct in numerous respects and overall was indicative of his guilt. After the accused wove webs of deceit for years, he finally removed his wife, probably in anger when she was interfering with his work and multifaceted life. Judging by his email to his mistress, he thought he could and preferred to continue his life with her by his side. In the final analysis of a holistic view of the testimony and documentation before me, and guided by the legal principles I have referred to, I have reached the following conclusions. The totality of the evidence points overwhelmingly to the guilt of the accused, considering legal principles quoted. I find that the state has discharged the onus resting upon it to prove the guilt of the accused beyond reasonable doubt. His version is clearly fabricated, cannot reasonably possibly or probably be true, and is rejected. The only reasonable inference from the totality of the evidence before court is that the accused was the person who killed his wife, placed her in the boot of her own vehicle, and set the vehicle alight to dispose of incriminating evidence, whereafter he supplied false information to the police. The manner and cause of death and the nature of the injuries inflicted and sustained showed that the accused had the direct intention to kill the deceased. The order I make in the circumstances is that I find the accused guilty of murder, guilty of an attempt to defeat the administration of justice. Yes, I was going to ask Mr. Webster what date he proposed that the matter should be postponed. Shall I stand down in the meantime?
Stand down and then receive for 5 minutes to change.
Certainly. The court will adjourn for a short while. After some discussions with the representatives, it has been decided that this matter will stand down until tomorrow morning at 10 o'clock for further discussions and decisions about the way forward in this matter and consultation with the accused by his representative. Is that
Does the
in
court
order,
please
Mr.
ready?
Webster?
Thank you very much.
Is that in order, Mr. Chairman? The court will, the matter is postponed until tomorrow morning at 10 o'clock. The accused will remain in custody. Thank you. Court will adjourn.
All rise.